Suggested answers to the 2018 bar examinations in political and international law. Question: Congress enacted a law to provide Filipinos, especially the poor and the marginalized, access and information to a full range of modern family planning methods, including contraceptives, intrauterine devices, injectables, non-abortifacient hormonal contraceptives, and family planning products and supplies, but expressly prohibited abortion. To ensure its objectives, the law made it mandatory for health providers to provide information on the full range of modern family planning methods, supplies, and services, for schools to provide reproductive health education, for non-governmental medical practitioners to render mandatory 48 on-hours pro bono reproductive health services as a condition to PhilHealth accreditation, and for couples desiring to marry attend a family planning seminar prior to issuance to a marriage license. It also punishes certain acts of refusal to carry out its mandates. The spouses Aguilos, both Roman Catholics, filed a petition to declare the law as unconstitutional based on, among others, the following ground. Letter A. It violates the right to life since it practically sanctions abortion. Despite express terms prohibiting abortion, petitioners claim that the family planning products and supplies oppose the initiation of life, which is fundamental human right, and the sanction of contraceptive use contravenes natural law and as an affront to the dignity of man. Letter B. It violates the constitutional prohibition against involuntary servitude because it requires medical practitioners to render 48 hours of pro bono reproductive health services which may be against their will. Letter C. It violates the freedom of religion since practitioners' religious beliefs prevent them from using contraceptives, and that any state-sponsored procurement of contraceptives funded by taxes violates the guarantee of religious freedom. Rule on each of the above objections. Suggested answer. Letter A. The law in question does not sanction abortion, even in practical terms. In the case of Imbong versus Ochoa, GR number 204819, April 8, 2014. The law on its face expressly mentioned that abortion is not permissible, and this was the determinative factor in making the ruling. In the same case, the court also found that the RH law was replete with provisions that embody the policy of protecting the unborn from the moment of fertilization. In addition, the majority of the court believes that the question of when life starts is a scientific and medical issue. Hence, the court refused to make a ruling on this issue. Letter B. Involuntary servitude denotes compulsion or coercion to do something, either force, threats, intimidation, or other means. The accreditation with the PhilHealth, as ruled by the Supreme Court in the case of Imbong versus Ochoa, should be viewed as an incentive and not a punishment. These health service providers also enjoy the liberty to choose which kind of health service they wish to provide. Clearly, there is no compulsion, force, or threat upon them to render the pro bono services against their will. Letter C. What is prohibited in the Constitution is the establishment of a state religion. While the Establishment Clause in the Constitution restricts what the government can do with religion, it also limits what religious sects can or cannot do with the government. They can neither cause the government to adopt their particular doctrine as policy for everyone, nor can they cause the government to restrict other groups To do so would cause the state to adhere to a particular religion and thus establish a state religion. Imbong versus Ochoa, GR number 204819, April 8, 2014. Question: Agnes was allegedly picked up by a group of military men headed by General Altamirano and was brought to several military camps where she was interrogated, beaten, mauled, tortured, and threatened with death if she would not confess her membership in the New People's Army, NPA, and point to the location of the NPA camps. She suffered for several days until she was released after she signed a document saying that she was a surrendery and not abducted or harmed by the military. After she was released, alleging that her rights to life, liberty, and security had been violated and continued to be threatened by violation of such rights, she filed with the Supreme Court a petition for the writs of amparo and habeas corpus with prayers for temporary protection orders, inspection of place, and production of documents and personal properties. The case was filed against President Amoyo, who was the President of the Philippines when the abduction, beating, mauling, and life threats were committed. General Altamirano and several men whom Agnes was able to recognize during her ordeal. The court, after finding the petition to be in order, issued the writ of amparo and the writ of habeas data and directed the respondents to file a verified return on the writs and directed the Court of Appeals CA to hear the petition. The respondents duly filed their return on the writs and produced the documents in their possession. After hearing, the CA ruled that there was no more need to issue the temporary protection orders since the writ of amparo had already been issued and dismissed the petition against President Amoyo on the ground that he was immune from suit during his incumbency as president. Agnes appealed the CA ruling to the court. The appeal was lodged after President Arroyo's term had ended. Was the CA correct in saying that the writ of amparo rendered unnecessary the issuance of the temporary protection order? Suggested answer: yes. The writ of amparo is an ordinary and independent remedy that provides rapid judicial relief, as it partakes of a summary proceeding and requires only substantial evidence to make the appropriate interim and permanent reliefs to the petitioner. It serves both preventive and curative reliefs in addressing extrajudicial abduction and torture. Temporary protection orders are merely intended to assist the court before it can arrive at a judicious determination of the amparo petition. A temporary protection order, being an interim relief, can only be granted before final adjudication on the amparo case is made. The privilege of the writ of amparo, once granted, already entails the protection of the aggrieved party. Thus, since the writ of amparo was already granted and issued, there is no more need to issue a temporary protection order. Llano versus Sanchez, GR number 186640, February 11, 2010. Rodriguez versus Macapagal Arroyo, GR numbers 191805 and 193160, November 15, 2011. Will the President's immunity from suit continue even after his term has ended, considering that the events covered by the petition took place during his terms? Suggested answer: no. The presidential immunity from suit exists only in concurrence with the president's incumbency. A non-sitting president cannot claim immunity even if the acts complained of were committed while he was still a sitting president. The reason for this is that if the immunity is not granted while he is in office, he might be spending all his time in attending to litigations. After his term, he can already attend to them. Estrada versus Desierto, GR numbers 146710-15, 146738, April 3, 2001. Rodriguez versus Macapagal Arroyo, GRs number 191805 and 193160, November 15, 2011. Question: what and whose vote is required for the following acts? The repeal of a tax exemption law. Suggested answer: the Constitution is silent on the voting requirement for repealing a tax exemption. However, it could be considered that the voting requirement to grant is also the voting requirement to repeal. Hence, the required vote is the majority of all the members of the Congress. Alternative suggested answer: the granting of tax exemptions requires the majority of all the members of the Congress because granting such will impair the lifeblood of the government. Repealing such tax exemption, however, is not inimical to such lifeblood, and a simple majority is needed instead of a qualified majority. A declaration of the existence of a state of war. Suggested answer: two-thirds of all members of Congress voting separately. Article 6, Section 23(1). Letter C. The amendment of a constitutional provision through a constituent assembly. Suggested answer: the proposal for the amendment shall be valid upon a vote of 3/4 of all its members. Article 17, Section 1(1). For the effectivity of the amendment, however, the vote needed is majority of all those who voted. Article 17, Section 4. Letter D. The resolution of a tie in a presidential election. Suggested answer: a majority of all the members of both houses of Congress voting separately. Article 7, Section 4. Letter E. The extension of the period for the suspension of the privilege of the writ of habeas corpus. Suggested answer: the Congress voting jointly by a vote of at least majority of all its members in regular or special session. Article 7, Section 18. Question: the province of Amaya is one of the smallest provinces in the Philippines with only one legislative district composed of 4 municipalities. 1, 2, 3, and 4. Andres, a resident and registered voter of 4 municipality, ran and was elected as member of the Sangguniang Panlalawigan of Amaya in the 2010 and 2013 elections. While Andres was serving his second term as SP member, a law was enacted reapportioning the 4 towns of Amaya into 2 legislative districts, 1 and 2 comprising the 1st district and 3 and 4 comprising the 2nd district. In the 2016 elections, Andres ran and was elected as member of the SP of Amaya representing 2nd district. Andres seeks your legal advice regarding his intention to run as member of the SP of Amaya for the 2nd district in the next local election in 2019. What will you advise Andres? Suggested answer: my advice is for him not to run for the SP member because doing so violates the limitation of 3 consecutive terms upon local elective officials. In the cases of Latasa versus Comelec, GR number 154289, December 10, 2003, and Daval versus Comelec, GR number 207851, July 8, 2014, the court ruled that the 3-term limit applies notwithstanding any reapportionment, renaming, or reclassification of any local government unit. The clear intent of the framers of the Constitution was to limit the term to 3 consecutive elections to the same position. Question: state whether or not the following acts are constitutional. Letter A. A law prescribing as qualification for appointment to any court lower than the Supreme Court, Philippine citizenship, whether natural born or naturalized, 35 years of age on the date of appointment, and at least 8 years as a member of the Philippine Bar. Suggested answer: the law prescribing as a qualification for appointment to any lower court, mere Philippine citizenship, whether natural born or naturalized, would be unconstitutional with respect to appointments to collegiate courts, CA, CTA, Sandigang Bayan, because all appointees to these courts must be natural born citizens. Article 8, Section 7. Letter B. A law requiring all candidates for national or local elective offices to be college degree holders. Suggested answer. The law requiring all candidates for national or local elective offices to be college degree holders should be considered as unconstitutional with respect to national elective offices because it is not one of the qualifications specifically required for these offices. The qualifications for these positions under the Constitution are exclusive in character, and the Congress would be incompetent to prescribe this requirement as an additional qualification for candidates for national elective office. This additional requirement would, however, be valid with respect to candidates for local elective posts. Social Justice Society versus Dangerous Drugs Board 570 ISCRA 410. Letter C. The designation by the President of an acting Associate Commissioner of the Civil Service Commission. Suggested answer. Such designation is unconstitutional because the Constitution provides that no person shall be appointed or designated in any of the constitutional commissions in a temporary or acting capacities. Articles 9B, Section 1, Paragraph 2, 9C, Section 2, and 9D, Section 2. Letter D. The appointment by the President as Deputy Ombudsman of a lawyer who has been engaged in the practice of law for 5 years. Suggested answer. The appointment can be upheld because only the Ombudsman is required under the Constitution to have been engaged in the practice of law for at least 10 years prior to his appointment. Article 11, Section 8. And letter E, the nomination by a national party list of a person who is not one of its bona fide members. Suggested answer. The nomination is invalid because nominees of national parties must be bona fide members of such parties. Atong Paglaom versus Commission on Elections 694 ISCRA 477 GR number 203766 April 2, 2013. Question. Ang Araw, a multi-sectoral party list organization duly registered as such with the Commission on Elections, was proclaimed as one of the winning party list groups in the last national elections. In its first nominee, Alejandro assumed office as the party list representative. About 1 year after Alejandro assumed office, the interim Central Committee of Ang Araw expelled Alejandro from the party for disloyalty and replaced him with Andoy, its second nominee. Alejandro questioned before the COMELEC his expulsion and replacement by Andoy. The COMELEC considered Alejandro petition as an intra-party dispute, which it could resolve as an incident of its power to register political parties. It proceeded to uphold the expulsion. Is the COMELEC's ruling correct? Suggested answer. Alejandro's petition should be dismissed for lack of jurisdiction. It is the HRET which has jurisdiction over the case because Alejandro is already a member of the House of Representatives. Lico versus Commission on Elections, GR number 205505 September 29, 2015. The 2016 mayoralty case in the city of Ardanya included Arnaldo and Anaclito as contenders. Arnaldo filed a petition with the COMELEC to cancel Anaclito's certificate of candidacy for misrepresenting himself as a Filipino citizen. Arnaldo presented as evidence a copy of Anaclito's Spanish passport and a certification from the Bureau of Immigration showing that Anaclito used the same passport several times to travel to and from Manila and Madrid or Barcelona. In his comment, Anaclito claimed that a year prior to filing his COC, he had complied with all the requirements of RA number 9225, the Citizen Retention and Reacquisition Act of 2003, to reacquire his Philippine citizenship by taking an oath of allegiance and executing a sworn renunciation of his Spanish citizenship. He defended the use of his Spanish passport subsequent to taking his oath of allegiance to the Philippines as a practical necessity since he had yet to obtain his Philippine passport despite reacquiring his Philippine citizenship. Even after he secured his Philippine passport, he said he had to wait for the issuance of a Schengen visa to allow him to travel to Spain to visit his wife and minor children. Question: based on the allegations of the parties, is there sufficient ground to cancel Anaclito's COC? Suggested answer: the sole act of using a foreign passport does not divest Anaclito of his Filipino citizenship, which he acquired by repatriation. By representing himself as a Spanish citizenship, he, however, Anaclito's voluntary and effectively reverted to his earlier status as a dual citizen. Such reversion was not retroactive. It took place the instant Anaclito represented himself as a Spanish citizen by using his Spanish passport. He is thus disqualified for being a dual citizen and his COC should be cancelled. Makiling versus COMELEC, GR number 195649, April 16, 2013. Note: the use of the foreign passport amounts to a recantation of the oath of renunciation required to qualify one to run for an elective office.